Now we're going to look at the case of Landis versus William Fannin Builders Incorporated. Landis is the plaintiff, and Landis is the single name that we'll use for the two homeowners named Steve Landis and Nancy Weidman. The judgment of the Franklin County Court of Common Pleas was in favor of the plaintiffs, Landis, and this court affirms. First, let's look at the concept that we're looking at here. Sometimes the relief is just unreasonable if it is based on the cost to rectify the problem that is left by insubstantial performance by the contractor in the building contract. Sometimes it's disproportionately high, and courts will look for some other measure of damages to award to the plaintiff homeowner if indeed the plaintiff homeowner deserves damages, which they do in this case. They contracted with Fannin Builders to build a $356,000 dream home, and they specified a lot of the material that would be used in constructing the home, including a particular type of siding that would be painted or stained, I suppose, with a particular product that would be, let's see, natural and rustic looking. So the builder chose a semi-transparent stain in a green color named Allagash. The Allagash stain didn't work. It provided some darker places and some lighter places, and it was described as a patchwork of different colors. And for a long time, the builders and the homeowners really tried to find a stain that would work right. And they'd take boards off and stain them and put them back and see if it looked like the other boards and so on in the siding. They never got to the point where it worked. So the plaintiffs, the Landis couple, filed a complaint with the Professional Standards Committee of the Building Industry Association of Central Ohio. And they concluded, that committee, that the performance of the builder did not meet the standards of the industry, did not comply with professional standards. So ultimately, they sued the Landis folks, and the builder sued for about $4,000 left on the payment for the house. Well, at a bench trial, they were awarded $66,000 plus, and then it was offset by the $4,000 or so that they had not yet paid to the contractor, for a total of approximately $63,000. And the damages were based on the cost of replacing the siding. The other way that the damages could have been calculated would be to determine the difference in market value between the way the siding turned out and the way the siding should have been, the market value of the house. Well, experts testified that the diminution in value of the house, the market value, was about $8,500. And the cost, as I mentioned, to replace was that roughly $67,000 number. Take all the siding off, put new siding back, stain the appropriate color. So the court struggled with the difference between the two methods of calculating the damages. So what did they do? They looked at the appropriate measure of damages, generally speaking, in an action for a breach of a construction contract, and they say it's the cost to repair the deficient work. That is, the cost of placing the building in the condition contemplated by the parties at the time they entered into the contract. That brings up the concept of economic waste. If a repair of a construction defect will involve unreasonable economic waste, damages are measured by the difference between the market value that the structure contracted for would have had and that of the imperfect structure received by plaintiff. Economic waste arises, the court says, when the total cost to remedy a construction, replace the siding, in this case, remedy construction defect is grossly disproportionate to the good to be attained. The economic waste concept arises from the court's disinclination to award windfalls. A windfall, in this case, to the Landis folks. How would that work? Well, suppose the court awarded them $67,000, which it did in this case. They could choose to keep the siding as it was, this patchwork, maybe hoping that the weather would improve it over 2 or 3 years, or maybe deciding to paint it with an actual paint that would cover up the problem. But they'd keep all this money, and that would be a windfall for them. That's the problem that courts are struck with when they are disinclined to award damages based on the amount necessary to remedy the defect in construction. Well, the court looks to a Supreme Court, state Supreme Court, holding that the essential inquiry is whether the damages sought are reasonable. And this court concludes that the reasonableness test announced in an earlier case, the Supreme Court case, precludes a strict application of the economic waste rule. Damages should be measured by that which will make the injured party whole. So there's this balancing that the court has to do. It has to make the determination, well, is this money going to be pocketed by the plaintiff and result in a windfall for the plaintiff? Or is it really the amount that's essential to be ordered and not too far out of line, meaning not a huge amount? If the cost to fix this defect, for example, were $250,000, I think the court probably would have gone the other way. One reason the court ruled this way in this case, I think, is because of the nature of the building that the contractors were hired to do. The contracts were hired to build the dream home. And the dream home included natural-looking siding. That's what these folks wanted. And that's what they contracted for. Not a home, but a custom-built home with the aesthetics appellees desired, and which Fannin failed to produce. Now, what if the court had awarded the $8,500, the diminution in fair market value of the house based on the crummy siding compared to the dream home siding? This court held that $8,500 could not fully compensate appellees. The cost to achieve the rustic look is the only reasonable measure of damages. How do you feel about that? I think it's a good decision.